So now towards everyone's beloved topic, charitable and religious trust. Our next session will be conducted by our favorite duo, Manoj Fogla, senior partner at LLP, and Suresh, senior partner at LLP, and Suresh Kejriwal, partner at Agarwal Kejriwal and Co. A very warm welcome to both of you. Manoj Fogla, a fellow of Institute of Chartered Accountants of India, holds a law degree and PhD from Utkal University on social accountability standards for NPOs. He is an expert in taxation, CSR, FSCRA governance. With over 30 years of experience, Manoj has served various charitable sectors, including education, religion, and the environment. He offers advisory, compliance management, and litigation support services. He has authored Trust and NGO Ready Reckoner and several FAQs on GST FCR for the ICI. Manoj is also frequently faculty member at the national and international forums. We also have Suresh Kejriwal, a chartered accountant and a founding partner of Messrs. Agarwal Kejriwal and Co. in Kolkata. He has over 32 years of experience specializing in NGO sector across India, Bangladesh, and Nepal. He teaches the Diploma in Financial Management and Accountability at the Tata Institute of Social Sciences in partnership with Financial Management Service Foundation. Suresh served on the Cooperatives and the NPO Sectors Committee of ICI for 2013-14 term. He's an associate author of Taxation of Trust and NGO by Taxmann and contributing to drafting ICI's FAQs on GST for NPOs. He has led numerous workshops and seminars on NGO sector topics for various institutions, including ICI. It's an honor to have you both on board, sir.
Thank you.
I hope you both are doing great.
Yeah, thank you.
Thank you so much.
Thank you.
So without further ado, the stage is all yours to take.
Yeah, thank you, Ridhima. Today we will be discussing on the amendment pertaining to the charities in the budget 2024. So at the outset, I will take you through to the major, in a layman's language, I will take you through the major amendments, and then Suresh ji will take you threadbare to the nuances of the act. So I have jotted down, there are five major areas in which we find the amendment in charities has happened. In fact, if you see the amendment of charities, you cannot see, you will be able to make a meaningful analysis if you take 1 year at a time. Particularly for the last 4 or 5 years, 4 years or 5 years taken as a block of period, you will make some sense about the way and where the charity related amendments are moving. This year, the most major defining amendment is that all approved category of organization under section 1023C will no longer be allowed approval under 1023C. So therefore, we will have only one category of registered institution for charitable, religious, solely educational, solely medical, all kind of institution will come under one umbrella. That will be section 12A, read with section 12AB. Now, let me just give you a brief context. Under the prevailing law, there are 9 different sections under which charitable and religious organizations can take tax exemptions. 8 categories under section 1023C. Under 1023C, there are 8 categories, 4 categories which are directly exempted without any need for going to the commissioner for approval. While filing the return, you can just declare that you are an organization. So those 4 organizations are government-funded schools, government-funded medical institutions, educational institutions below 5 crore, medical institutions. So these are exempt category, any kind of approval, and they have kind of a blanket exemption. So they are not subject to various compliances, 85% application, specified investments, payment to specified persons. So those 4 categories will continue. Then you had another 4 categories under 1023C, clause 4, 5, 6, and 6A. Here, We had four categories of institution of national importance or state importance, specifically religious institution, specifically charitable come religious institution, solely educational institution, and solely medical institution. These institutions were specially approved by the CIT or the PCIT, and these were considered as two parallel regimes. Initially, when these provisions came, the regimes were not parallel, because if you remember in 2021, the budget, a lot of changes came in Finance Bill 2001, which more or less merged the differences between 1023C and 12A. Before 2021, a 1023C registered organization could accumulate funds without filing Form 10 or Form 9. The amount accumulated beyond 15% were not required to be invested in specified investment. There was no penal provision for making payment to specified persons. There was no provision pertaining to activity outside India. So there were a host of privileges enjoyed by organizations registered under 1023C. Those in any case were nullified over the years. This year, the entire segment of exemption under that section has been removed. Now onward, the cutoff date is 1st October 2020. The problem is that though they have removed, but the sunset clause will be 2029, because up to October 2010, the commissioner will go on issuing 1023C registration. Beyond October 2024, 1st October, no more exemption under this category. So this will be a transition over a period of time. Then another which has not been noticed very well, that a provision has been added to section 12A1AC clause 6. If you remember, from 2021, this new scheme of taxation came, and all existing organizations were required to apply in Form 10A to regularize their registration under the new scheme, 5-year registration. And many organizations, due to lack of awareness, technical glitches, selecting the wrong code because of so much of complex provisions, were unable to apply. And there were so many circulars. The last two circulars in the last 1 year were circular 6 and 7. And 30th June was the last date till which organizations whose registration expired in March 2021 are allowed to apply after a gap of 4 years. All this happened because the Act did not have a provision empowering the commissioner to allow condonation of delay in filing of an application form for either new registration, renewal, or regularization. Now in the Act, there is a provision which empowers the commissioner to allow condonation of delay, of course with reasonable cause, in all category of application. This is a much needed relief, and the organizations who failed to take advantage of Circular 7 by 30th June, they can still apply for new registration, because the Act says clause 1 to 6, and clause 1 is regularization of 2021 registration. Then we have a altogether new section added, section 12AC. This section is about merger of charitable institutions. Now, due to various reasons, merging of charitable institutions and religious institutions had been a big issue, and issue under the trust laws, the societies laws, Companies Act, as well as the Income Act. All the 4 statutes related to charities are not very enabling in nature to provide a reasonable or an appropriate way forward for merger. So now, at least under the Income Tax Act, there is a section which says if two charities merge, then this merger will be permissible. And why it is most important under Income Tax Act? Suppose you dissolve a charity, then the dissolution of charity itself will attract section 115 TD, that is accredited tax. So that was the reason whenever we were asked to do tax planning, we used to suggest that please don't uh, try to merge. Better to the organization can be dissolved. But now, at least the Act provides merger of charities, and the demerged defunct will not be subjected to 115 TD, even if it surrenders the 12A registration. Then one more amendment, though it has in some sense increased complexities, under 80G below the section where application for provisional registration, where activity has commenced, provisional registration for activity has not commenced, and direct registration for activity has commenced. There, in both section 10, all the three sections, 1023C, 12A, and 80G, a very arbitrary provision exists, and it exists even today. All these sections say that you cannot apply for a fresh registration under section 12A, 80G, or 1023C if in the past ever you had taken benefit of that particular section under section 12A and 1023C. So now, if your 12A registration has not been renewed for any reason, you cannot apply for 12A registration any time in future. That is the provision of the law. That is the provision under section 12A1 AC clause 6. So under 12A it has not changed, but under 80G it has changed. So now organizations can apply for 80Gs, but this provision will have very limited utility. It will help only those organizations who had 12A registration but never had 80G registration. These organizations can apply for 80G. For other organizations, unless there is a corresponding amendment under section 12A, this provision will be of not much help. Then lastly, section 47 has been amended, the definition of transfer. And now gift of capital asset will not be treated as a transfer, and primarily corporate entities cannot gift capital assets, land, etc. to charitable institution. This, I think, is a provision which should be reconsidered, because the explanatory memorandum says that gifts should be related with natural love and affection, and in a corporate there is no cause for natural love and affection. But a corporate giving for a social cause or a public cause reflects social empathy and corporate citizenship, which should be considered higher than a normal individual love and affection. So this will have a lot of cascading effect. We find corporates donating various kinds of assets to deserving beneficiaries, movable, immobile, etc. Those will be subject to tax. What will be the tax implications? We are not discussing. So I briefly took you through the provisions. We have very little time. I will ask Suresh to quickly run through some of the key provisions, and then we will discuss few key issues. Thank you.
Thanks, Manoj for setting the context by sharing with us the overview of the proposed amendment. And what I will do is shall initiate the detailed analysis of some of the key proposed changes. Let me share my PPT. So Manoj has given this. Manoj, am clear?
Yes, sir.
Okay, my PPT is visible.
No, not at
Okay,
all.
okay.
I guess you have to share it again.
You share it again, and Suresh, you can continue. You can continue while the PPT
Okay.
comes.
Okay, no, I am to. So I will just stop here.
Is there any problem?
I am not able to share the PPT. So I'm before PPT. I'm just going then.
Okay.
Yesterday it was going on. Just let me try again because PPT would have been better.
Yeah. No worries, take your time.
Okay. ये PPT क्यों नहीं शेयर कर पा रहे हैं? यहाँ पर आके नहीं रहा है. उनको बुलाओ तो.
Share का option है ना इसमें. मेरे को तो पहले करना.
लेकिन इसमें तो बना नहीं रहे नीचे. जैसे ये PPT है.
Sir, open it once.
I am opening the PPT. I am downing it. Now here.
You can mail me, I'll share it quickly.
Suresh, you don't bother about the PPT. You continue.
Okay.
Yeah.
Okay, I am audible.
Yes.
So the first PPT is better thing. So first detailed analysis is on the gradual merger of two regime. That is first regime to second regime, and as Manoj ji has rightly said, that 1026C has two different category. One is non-approval category, and another is approval category. So this will this non-approval category will stay, and this is not going to merge even after gradual shifting from second regime to first regime to second regime. Only the second regime, first regime is going to be merged with the second regime. Now, what is the process of this regime with shifting? They have closed the window to apply for new approval on or after 1/10/24, meaning thereby up to 30th September 24, the first regime applications can be made, and the CIT has to consider that application if the application has been submitted before 1st October 24, meaning thereby after 30th September 24, no new application, but the entities which have already got the 2026 approval shall continue. That means parallelly, though there will be no new entry to this first regime club, but all the existing organizations which have already been approved shall continue to operate. And as Manoj has rightly said, and this way the 29-30 assessment year shall be the sunset clause when the first regime will going to be totally merged with the second regime, but non-approval category will still to continue without any change. So Manoj, the first issue is, or we will take up the question at a later stage. Now the second change is the much needed continuation of delay, which Manoj has also said very nicely that at the time of submitting application for registration under either for one-time registration or for converting provisional to regular registration or for change in object, whenever there is a delay, the delay continuation power was not with the CIT exemption, and those applications were refused. And in those cases, either we have to go to the CBDT for 119 or we have to go to the Income Tax Appellate Tribunal, though government has given a number of circulars extending the timeline. Now the government has realized this difficult task and has given this power, proposed this continuation power to the CIT exemption, and this exemption power has been given to all the type of registration under Section 12AB. But ironically, this again has not been given. Similar power of continuation has not been given for ATG approvals. And again, the circular 6-like position will prevail, where though you will get the 12AB registration through continuation, but you will not get ATG approval because there is no continuation power to the CIT exemption. And again, we have to go to the CBDT or to the ITAT. So I think the government should take a view that in both the places, the continuation power should be there. Now, coming, the next key amendment is the new section for merger for charities. As we all know, presently Income Tax Act doesn't deal with specifically on the merger or amalgamation of the trust. An irrevocable trust, whether it can be dissolved, again is a question for debate. And the beginning is being made by inserting a new section under Income Tax Act, which provide that one registered trust can be merged with another trust, provided they carry the same or similar objects, or they meet the specified conditions which are yet to be prescribed. So I think this is a welcome provision because in number of groups we find a number of trusts is operating and they want to merge to cut down the number of trusts because of the compliances issues. And this provision shall be a welcome provision for those type of requirement. But at the same time, we have to also go through the constitution document, the law under which we are incorporated, the state laws where applicable, and we have to take a consolidated view whether we can at all go for the merger or not, and what are the conditions we have to meet. Now, another key change is the opening of the window for ATG approval, where it was closed from 1/10/23. We all know ATG approval was not always taken at the time of taking 12AB registration, and the NGO tend to take ATG approval when they started to wanted to raise CSR fund, or they wanted to raise local fund. But incidentally, from 1/10/23, a provision has come that if you are going to apply for the first time for ATG approval and you are an entity which has already commenced activity, then one of the conditions that you should not have taken benefit of Section 11, 12, 13 or Section 1023C in the past. But in such cases, always the entity was already registered under Section 11, 12, 13, and so they were not satisfying this condition and they were not eligible to apply for ATG approval, though they are going with the 12AB registration. And this created a great deal of hardship for those type of entities, because for raising CSR fund, holding ATG and 12AB registration is a must. I think the proposed amendment done away with this condition, that the requirement of whether the NGO has a past exemption benefit or not. Now there is no such requirement, and now the NGO can apply for ATG approval at any time. But again, this corresponding provision also exists in 12AB registration, meaning thereby, though in cases where 12AB registration is there, in those cases the entity can avail in this amendment and can get the ATG. But take for example, for certain regions, the ATG has been cancelled, 12A has been cancelled for some entity, and they wanted to go ahead with new registration, again registration under Section 12AB. In those situations, as the entity has already taken a benefit of 11, 12, 13, that entity will not be allowed to apply for a 12AB registration. Though that entity, after this amendment, can apply for a ATG registration. But again, for ATG registration, having 12AB is a must, is a precondition. And that's why we understand similar amendment which has been made for under ATG should also be given under 12AB, so that the same level ground fit can be there for both type of entities. And lastly, the changes by the which Manoj ji also mentioned about gift of capital asset to the charitable entities may be subjected to tax under Section 47. Those the Section 50C and 50D are deeming provisions maybe in the rescue of the NGO, but the way the budget memorandum explained, I think that will be a litigation, and the corporates will be discouraged to gift the immoral property which they own for a charitable purposes. So I think again the government should exempt the gift or continue to exempt gift for charitable purposes as exempt transfer under Section 47(3). Now with this word, I want to discuss with Manoj ji for the condonation power has been given only for ETG and not for 12 ABB. So how it is going to affect the NGO?
No, as we have already discussed, that 80G related condonation will only apply for those cases where 80G was never taken. Otherwise, 12A being a precondition to 80, this amendment doesn't make any sense. And maybe by the time they finalize the bill into an act, a corresponding amendment in 12A is necessary, though 1023C is also there, but we may not require an amendment there because of the phase out.
Secondly, Manoj ji, as we know that after 30th September, the window for applying 1023 approval shall be closed. Now take a case where the NGO has obtained the provisional approval under Section 1023C. So what he will do, and the 6-month time limit has not expired on 1/10/24. So whether she should wait for the NGO should wait for applying for a 12AB or what the NGO should do?
And if an application under 1023C has been made and the 6-month timeline has not been elapsed, then if the registration under 1023C is not issued prior to 1/10/24, then the NGO should get registration under Section 12AB.
So in those cases where the application for converting provisional approval to regular approval has not been made up to 30th September, then that particular entity has to submit regularization under 12AB.
Yes.
Next, after the new novel case, most of the NGOs, because of the word solely, have changed their object to only education. Now they will also shifting to the second regime. So what advice we have for those type of those entities?
This is a very important thing. We would seek the attention of all the viewers. A couple of years ago, we had a landmark ruling by the Supreme Court in the Noble Educational Society case, where it was said that under 1023C clauses, an organization has to be solely and it cannot engage in any activity. And it was suggested that even the bylaws should be changed. And many organizations changed their bylaws to make it a solely educational institution. Now there is a corresponding problem under Section 12AB. 12AB is a general section under which an educational institution with other objectives can also enjoy exemptions. If an educational institution shifts to 12AB, it is recommended that they may go for amending their bylaws prior to shifting, so that they will not have to apply again for modification of objects. Why we are suggesting that? Under Section 12AB subsection 4, one of the specified violation for cancellation is if an organization works beyond its own stated objects. Earlier it was if the organization works beyond objects as per Section 215, but now if you work beyond your own objects, it will be a stated violation. So better to have a broader object clause.
Thank you, Manoj. Before we close, we will take up one more question. As you have discussed about continuation of power to the CIT exemption in all categories of registration process. So whether the 5-year registration for the existing organization as on 1/4/21, whether they can still apply for 5-year registration after this continuation power, and when they can apply?
now it is quite typical. Now, after so many circulars and after 3 years, many organizations have still failed not to apply for regular registration, and their registration has expired from 31st March 2021. Some of them are facing scrutiny assessment as an AOP. Such organization also has a window because the act has been drafted in such a way that the condonation power is for clause 1 to 6, and clause 1 is specifically for 2021 registration, but it will become effective from 1st October 2024. So those organizations, in our opinion, should wait and apply after 1st October 2024 for condonation of delay. They may file a ask for permission to file Form 10A, and they should get their 12A registration regularized, even if it expired on 31st March 2021. So it is a huge opportunity. If some organizations are there, they should take advantage of it.
Thank you, Manoj. As the time is very short and we are near to completion of time, I will hand over it to the Radhimaji for taking any question from the dais. And before I end, I would like to thank Taxmann for giving us this platform to share our views. So over to Radhimaji for taking any questions.
Thank you so much, Manoj. Thank you so much, Kejriwal ji. I think this is, as always, a very informative session with you two, because you people actually dug deep into the details. That's pretty awesome. Just two queries before we hand over the session to the next speaker. First we have is, what constitutes for a reasonable cause for filing a condonation of delay request before PCIT and CIT? This we got on some forum.
Reasonable cause is a very generic term, and we don't have any special provision or any clause. So the definition is reasonable as applicable in civil law. So normally what we suggest, normally the reasonable cause in the past, because of the glitches, we have several tribunal decisions where technical glitches, selection of wrong code, etc. So if the organization has made effort to file a return or the application has failed, then that can be a reasonable cause. Otherwise, the organization, the reasonable cause are circumstances under which it was unable, and the organization normally tend to take the health or the medical ground of the key people or the finance officer. These are the standard causes we find as reasonable cause.
Correct. Interesting. And since Section 47 change, this proposed restrictions on the gift under Section 47 of the Finance Bill, how will this affect the charitable entities?
Charitable entity, in fact, it will, because any kind of capital asset, the corporates are discouraged, and we have been seeing that corporates have been given various kinds of capital assets, including, say, computers, etc., to beneficiaries, even vehicles, etc. A lot of things were being given to beneficiaries: used vehicles, used assets, used furnitures. So being in the charity sector for so many years, and we don't understand the rationale. I think this is one provision which will severely affect the charities, unless some tribunal comes to the rescue, seeing that this kind of transfer will not come under Section 50C and all those kinds. So those kinds of litigations will going to go. But on the face of it, it is not a very desirable change.
So it is. Yes, sir.
I agree with Manoj because it is not only corporate, other entities, even the LLP, where the government is going for the CSR. So this provision for charitable purposes needs to be reviewed. Transfer for charitable purposes needs to be reviewed.
It's a very open one right now.
Very open one. Only individual achieve. Only individual achieve.
Yeah.
Correct. Great. Thank you so much, sir. It's always an honor to have you both, and it was actually an engaging session as always. Thanks a lot.